Rick Essenberg is standing by from the Wisconsin Institute for Law and Liberty to talk about Act 10, and maybe if we've got some time, some other things. But the court decided to reject the petition for bypass of the lower court, the appeals court, on the Act 10 challenge. Thank you for coming on the program, Rick, and thank you for joining me on the Middleton Ford Hotline. So this doesn't mean the case is gone, even though the appeals court is going to be, I guess, more friendly to the argument to maintain Act 10. So how does this proceed? And then let's talk about a perspective of your client that no one is really mentioning, which is the harm that will be done from people who have benefited from this law.
Right. So what happens now is that briefing will take place in the Court of Appeals. And that'll take a little while. There is really no chance that the Court of Appeals will rule during the current term of the Wisconsin Supreme Court. So at some point down the line, maybe later this year, possibly even later than that, the Court of Appeals will, rule on its review of the circuit court's decision, and will decide that, it either agrees or disagrees, at least in part, with that decision. Then it will be up to somebody to petition the Wisconsin Supreme Court for review.
Okay, so it's now the process has been extended. Now the process is not fast-tracked. Now the Supreme Court race in April makes all the difference here, because the court, no matter what, depending on how the court is made up, that will determine whether or not this law is overturned. It really will, period. It will determine whether it is overturned. So, I mean, I can't put an exclamation point at the end of that sentence that is in bold enough type.
Yeah, and I agree with you. I mean, I think that, again, you never know for sure what somebody is going to do, but, the smart money would be that, the court will sit sixth, because Brian Hagedorn has recused himself, and I don't think that'll change before, when the case gets up to the court. And so, let's say that Brad Schimmel wins the race in the spring. Smart money would say that the court then at that point would be split 3-3 on the constitutionality of Act 10. And at that point, it becomes very important what the Court of Appeals does, because that is likely to be the controlling decision, at least for a while.
This is crazy. The whole race is going to be another referendum on Act 10. We should mention how many different court cases have found that law constitutional.
Well, if I recall correctly, there were four. Back when Act 10 was first. That's my recollection. There were four, and they all rejected the various constitutional challenges to Act 10.
Including a challenge that is directly on point to this case, which was about whether emergency personnel should be covered under the law.
Right. That was before the federal court in Madison. Judge Conley, who was an Obama appointee, he made clear in his decision that he didn't think much of Act 10, but at the same time, he did what a judge should do. He said, my personal opinion doesn't matter. I have to apply the law here. And as I look at the law and I apply it to the facts of this case, I have to reject the challenge to Act 10, and he did.
Good. I hope, I hope that we can see some of that channeled into the Wisconsin Supreme Court. The idea, I might hate this law, but there is nothing unconstitutional about this law. Incidentally, and I pointed this out when Governor Walker joined me on the program last week, early this week, I'm sorry. We have an entire body of law that treats law enforcement and emergency services personnel differently than other categories of public employees. And nobody is challenging that body of law. So if this case goes away, wouldn't that put that body of law at risk?
Well, it depends on the rationale that the court adopts. And I can tell you, I'm the son of a firefighter. It is a different kind of job. And people react in different ways when they're on a job like that. And what the court did, what applies, the standard that applies in a case like this is what's called a rational basis scrutiny. And rational basis scrutiny is a very, very low bar for a law to clear constitutionality. That when the court is applying rational basis scrutiny, it does not take a hard look at the statute and determine whether it's okay or not. And so under any traditional application of this rational basis scrutiny, Act 10 passes muster in its distinction of public safety employees from general employees, and even in its distinction among different categories of employees who could be characterized as public safety. What the Circuit Court did in Madison in holding that Act 10 was unconstitutional recently is very, very unusual. And if we're going to stick to the traditional ways in which these legal principles have been applied, the likelihood that it will survive appellate review is very, very small.
But it does sound like you were saying that if it somehow does and it gets repealed, that it could, the rationale, depending on the rationale of the court, it could upend some of these other legal, or the other legal restrictions on how we treat categories of employees.
I mean, could be. We don't know until we see the rationale that the court applies. I mean, so one of the things that happened in this case is, there was this question in the recusal of Justice Protasiewicz, which she's declined to do. One of the reasons that were offered for recusal is that she said in the course of her campaign that she agrees with the dissent in the Wisconsin Supreme Court case that upheld Madison, that upheld Act 10. In that case, the court, not getting too much into legal inside baseball, the court applied what's called strict scrutiny to the law because it concluded, although it tried to avoid saying this, but it basically concluded that there's a constitutional right to collective bargaining. If, in fact, we get a decision from the Wisconsin Supreme Court that there's a constitutional right to collective bargaining, Katie bar the door. I mean, that would be a very, very unusual and radical outcome.
Well, would it tee up a claim for back pay and compensation for people who were, quote, negatively affected by Act 10 or people who claim they were?
Well, I mean, I don't want to get into that, but it certainly would change things going forward. And, as our policy side has demonstrated, I mean, Act 10, saved taxpayers a heck of a lot of money, billions of dollars. And I think that, we're looking at a very, very different state going forward if a law that we thought, more than 10 years ago had survived all constitutional challenge, now is somehow ruled unconstitutional because the composition of the court has changed.
Yeah. And then that tells you everything else is up for grabs. Every other piece of reform, every law, everything that irritates the left-wing majority, if they maintain control of this court, will be up for grabs. Tell me about you are filing on this case on behalf of Christy Koschke, who's a teacher who benefited, and she says you're going to hurt me if you take this law away. And I don't think we've heard from that perspective before. There are a lot of teachers and a lot of public employees who are happy about this law.
Right. And so she's a teacher. She's very dedicated. She's what she does as a profession. And so she believes that she should interact with her employer individually and not as part of a group. She does not want a system of compensating teachers and dealing with the conditions of their employment that treats them all like fungible parts, which is what collective bargaining has a tendency to do. And so, she has opposed this. My gosh, we have represented her in a number of cases like this. She has a long history of standing up for the independence and the professionalism of teachers and wanting to be free to cut her own path and not be part of this.
Yeah.
Collective.
Well, I know her a bit. She's a high performing teacher. And so when budget crisis comes around and you need to look at, if you have to lay off personnel, she tends to survive because she's good. She's good at what she does. She can now, negotiate for compensation based on her talent as a teacher. And because of her good record as a teacher, she's not going to be canned just because, she doesn't sit right in the hierarchy of the union. Because prior to Act 10, it was a last in, first out. So the people who were hired, people were fired based on how recent of hires they were. And if you were recently hired or you weren't, an established tenured teacher, you were fired first. So, someone like Christy, back when Act 10 started, she was not somebody who had been in the profession a long, long time. So, it definitely benefited her to be a high performing teacher and protected from that stupid rule, if somehow the district finances went to the dumps.
Right. I mean, and, we got to remember, how Act 10, came about. The state was facing a fiscal crisis. It had gotten a lot of federal aid in the wake of the financial crisis in 2008. That money was running out. And as we went into Scott Walker's first budget cycle, the conventional wisdom is that we are either going to have to raise taxes significantly or we are going to have to significantly cut services. And both of those are unpalatable. And so what happened is Governor Walker found a third way. He said, no, I'm not, I refuse to make this decision between two bad choices. What I'm going to do is I'm going to reduce the cost of providing these services so we don't have to cut anything and we don't have to raise taxes. And, the people who really objected to that were public employee unions because, just as we see now in some of the reaction, to some of the examination of federal agencies that's happening in Washington, D.C., these are entrenched groups, particularly the unions, people who, make their money by sort of basically being the political representatives of these organizations. They don't like to have to be challenged in this way. And Act 10 did that. I think if you talk to a lot of municipal officials and people who are on municipal governing bodies across the state, they'll tell you that its impact was good. Not all of them, but certainly many of them. And in any event, we litigated the constitutionality of Act 10 a long time ago. And I think to bring this back now, making tired old arguments and arguments that really don't comport with the way that these concepts are typically handled by courts, I think is extremely unfortunate, to put it mildly.
Yes, that's very diplomatic of you. If I recall correctly, there were around 10,000 public employees that were going to be pink slipped in order to try to handle the $3.2 billion structural deficit that had been created by using one-time stimulus money for ongoing spending. So, I remember people saying that. We're about 10,000 employees too expensive right now in order to pay our bills. And we don't want to fire 10,000 employees. So the alternative was the budget repair bill, which came to be known as Act 10. That's ancient history for a lot of people now, but it wasn't that long ago. Rick Essenberg, I appreciate the time on the show. Thanks so much.
Thanks for having me.